Welcome to the Agent of Wealth podcast with Marc Bautis from Bautis Financial. In this podcast, Marc helps guide you towards financial freedom, ensure you never run out of money, and create a balance in life that prioritizes what is most important to you. Join us for this journey as Marc draws from years of expertise and guest experts to solve the multiple wealth building challenges involved in your financial life.
Hi, this is Marc. Before we jump into today's episode, I wanted to take a moment to recognize this pretty special milestone. This is episode 300. When we launched this podcast back in August 2018, I never imagined we'd have the opportunity to share 300 conversations about building wealth, making smarter financial decisions, and learning from so many incredible people. Over the years, we've welcomed more than 200 guests who have shared their expertise and their stories, covering everything from investing and retirement planning to entrepreneurship, real estate, taxes, cybersecurity, leadership, and the habits that help people build meaningful lives. Whether you've been listening since episode 1 or this is your first episode, thank you for spending your time with us. And I'd also like to thank my co-host, John Williams, along with every guest who's joined us and helped make this podcast what it is today. We're incredibly grateful to have you with us, and we're excited for what's ahead. Now, let's get back to episode 300. Welcome back to the Agent of Wealth. This is your host, Marc Bautis. Today, I'm joined by a special guest, Philip Crowley. Philip is a startup advisor, attorney, and founder of Crowley Law LLC. With a background spanning physics, research, Wall Street law, and decades at Johnson & Johnson, Philip has spent his career helping founders navigate the challenge of building and scaling companies. He's also the author of Avoid Startup Failure, where he shares lessons learned from working with entrepreneurs and companies on the challenges that can make or break a startup. Today, we're going to discuss two critical topics for founders and innovators: the biggest legal mistakes entrepreneurs make before launching a company, and the mistakes innovators make when protecting their ideas through patents. Philip, welcome to the show.
Well, thank you, Max. I am very importantly interested in these topics and glad to discuss them with you and with your listeners.
Great. So maybe you can start off, tell us a little bit about your background and your journey from physics research and Wall Street law to working with startups and founders today.
Sure, I'd be happy to do that. Well, I started out at Stevens Institute of Technology intending to become a research physicist, and I did well enough there to get into the PhD program in experimental physics at Harvard. But I learned as I was pursuing my graduate degree that I was becoming 7 miles deep, but only about half an inch wide. And it would be a long time before the things that I was working on in quantum mechanics and superconductivity that were going to actually help people. And that's what I wanted to do. And I looked back at my career at Stevens, and I had taken some psychological tests in a psychology course I took that I'd blown off at the time, which suggested very strongly that my interests weren't really that much aligned with physicists, but they were more aligned with chemists, with lawyers, and with computer programmers. And so for most of the past 40 years, I've been a lawyer dealing with the life sciences and technology. And, that has been what has really motivated me. After Harvard, I left with my master's degree, and I said, well, let me try industry, because I don't want to look back in 30 years and say, gee, I wonder what it would have been like if I had been a research physicist in industry. So I took a job as a senior research scientist at Corning Glassworks. And I could see that that was sort of more of the same thing. So I applied to law schools. I got into Columbia in New York and did well enough to be able to go to Wall Street law firms and learn to do mergers and acquisitions and securities and bank financings. But I still had that bug about technology, and I wanted to use it in some way. And Johnson & Johnson was looking for a corporate kind of commercial deal lawyer. And I said, well, I'll try this for a couple of years. And I got into it and found out that I could learn a bit about the business, and then also learn this new craft at the time, which was medical device law and regulation by the Food and Drug Administration. So I got involved in that as well. And at one point, I was the chief FDA regulatory counsel for Johnson & Johnson's biotech companies. And it was really fascinating for me because I was really interested in the businesses and the business side and helping businessmen to use law to achieve their business aims, because we really had a very practical mindset in the Johnson & Johnson Law Department that our job was to help the businessmen to effect their business goals in a way that was legal, ethical, and for Johnson & Johnson, consistent with the Johnson & Johnson credo. And that's one of the reasons why instead of staying just 2 years, I wound up staying 32 years in the Johnson & Johnson Law Department. But during my career, I could see the big firms were slimming down their internal research efforts because they just couldn't innovate. They were too bureaucratic. And there were these little companies that could set up around really great ideas, pivot quickly when they had to pivot, and create intellectual property that was incredibly valuable. And then the big companies would either license the technology if it was a patented technology or buy the company for big numbers. And I decided as I was retiring from Johnson & Johnson, well, those are the companies that can really use my help. And at this point in time, I could see that in many cases, the people who were doing the great innovative work weren't protecting themselves. And as a result, after a few years, in many cases, the innovators would get kicked to the curb or get tremendously diluted in terms of their equity interests and wouldn't really benefit that much from the tremendous wealth that they had led the creation of. And so I said, those people need help, and I felt that it would be a privilege for me to start to help them. And so that's when I got the idea. I retired from Johnson & Johnson on Friday, had the retirement party on Saturday, recovered on Sunday, and started Crowley Law on Monday because I just love doing what I can do for these companies. So that's how I got to start things off. And then I've attracted a group of another 3 very experienced lawyers to help me help these folks who are creating great ideas and helping them take them from the laboratory bench to the patient's bedside, or from the garage to the marketplace to enrich the lives of thousands or even millions of people. It's a great high to be able to see that.
All right. So when a founder is in, let's say, the earliest stage of building that company or coming up with the idea, what are some of the legal mistakes you see them make before they officially launch?
Well, one is not having a limited liability entity in place to run the business soon enough. At least a limited liability company, which is easy to set up, or a corporate form, in order to ensure that their personal assets are not at risk with respect to the business. The second thing that I see is that people seem to think that they can't engage with a lawyer without spending tens of thousands of dollars. And the truth is, if you can find a firm that's interested in helping startups, you can get that help a lot sooner. And particularly, there are many accelerators around that provide assistance, mentorship, and realize that you don't have to do it all on your own. There are people out there, lawyers and others, who dedicate their time at no cost or very little cost to help startups get themselves started. Because what I find is that many startups don't engage, at least informally, with a lawyer soon enough, and they get themselves in trouble. For instance, they'll be given a letter of intent that says, well, this letter of intent is non-binding. So they say it's non-binding. So, what's the legal risk there? The problem is that when you enter into a non-binding letter of intent or term sheet, it's non-binding. It doesn't bind the parties to go forward. But if a particular protective term for you as the entrepreneur isn't in the term sheet, it becomes very difficult to get that into the final documents. And in addition to that, if there are things in the term sheet that you don't like, you really need to negotiate those up front, because it will be extraordinarily difficult to change those without blowing up the deal. And so having a relationship with some knowledgeable mentors, an accelerator, or a lawyer that focuses on startups early on is helpful. And particularly in New Jersey, Max, there are a number of accelerators around, particularly for technology companies, where entrepreneurs can get a start, can get mentorship, even if they wind up not being resident at the accelerator, to go out and talk to people who have businesses that are similar to yours and learn from them who they rely on, who they talk to, and begin to get into the community of innovators, because you don't have to do it completely on your own. Having people kind of pepper you with questions about your technology and your approach is very helpful to make sure that you avoid blind spots. The other thing, though, to be concerned about is protecting your intellectual property. And another mistake that entrepreneurs sometimes make is being too descriptive of their technologies before they have a non-disclosure agreement in place. The non-disclosure agreement protects your information, assuming that you're working with a reliable person, so that when you have a discussion with an intellectual property law attorney, a patent lawyer, you can assure that your information has not been disclosed without limitation, and disclosed, as we call it, it's in the public domain, because great ideas that are in the public domain aren't patentable. So once you disclose something, you have a grace period in the United States of 1 year to file a patent. However, you will have lost all of your international patent rights, because there's no grace period outside the United States. And if you're looking to maximize the value of your great ideas, you have to protect them and work with a skilled patent lawyer to determine what is and what is not patentable, and then to get in place what is called a provisional patent application. So that sets a mark, a stake in the sand at a particular point in time. And anything that comes after that is subject to being overridden by your pre-existing invention. And I've seen people and seen advertisements for people who claim, well, we'll file a provisional patent application for you for $500. And in the intellectual property world, you get what you pay for. The protection that you get for a poorly drafted provisional patent application can be very small, because the patent application may be drafted so narrowly that it's very easy for somebody to innovate around it. And so you don't have really good practical protection. And so making an investment in yourself, really, and in your technology early is an important part of being a technology entrepreneur. And then managing the risk that you incur as an operating business by having some kind of a limited liability entity is also very important early on. Those are two of the key mistakes that I see. And yeah, I put out in my book, Avoid Startup Failure, learn the top 10 causes of failure for technology startups, and how to turn them to your advantage. I list all 10 of them. And for those of you who fear that this is one of those lawyer books where we give a list of 75 things, and if you miss one of them, you're doomed, I tell the story of a likable young man from the Midwest who comes from a humble background, works hard, becomes a technology expert, and then goes out to commercialize some university technology and makes just about every one of the top 10 mistakes. And you get to see what happens in a story format. And then I analyze it. And then in the third part of the book, I talk about the kind of documents that you will see if you become moderately successful and attract angel investors to invest in your company, or venture capitalists to invest in your company. Because money is the fuel that will make you grow. And with some exceptions for some of the IT-based software as a service kind of businesses that may be able to self-generate funds because it's so easy to license software. But those are the things that I would caution people about.
Going back to one of the things you said about the structure and setting up a limited liability company, setting up the structure to limit the risk of your personal assets. Is there any difference if someone sets up, say, an LLC or some kind of other corporate structure like an S corp or a C corp, with respect to their personal assets being at risk?
Setting up a limited liability company is probably the least expensive way to start and the easiest one to manage. Setting up a corporation requires a bit more of paperwork and documentation and filings with the state. The advantage, there are substantial tax advantages, though, to having a corporate status. And this is one of the reasons why it's good for entrepreneurs to have a discussion with your tax advisor, a knowledgeable business tax advisor as you start. There is a section in the federal law that's replicated in now 46 states, including recently New Jersey, that exempts from capital gains tax the first up to $15 million of gain from the sale of qualified small business stock. Doesn't apply to limited liability companies. So that having a corporation in place provides potentially tax benefits down the road. And while you can change from a limited liability to a corporate status, you should keep that in mind, because maximizing the benefits of all the work you put into the company is one of the key items. And particularly in New Jersey, it's not how much money you make, it's how much money you keep. And so having good tax advice is important as well.
What about the state that someone incorporates in? Is there, you hear, it used to be, no matter what state you're doing business in, incorporate in Delaware. Or I know there's some other states that come up a lot. Is there really a difference, or are there some states that are more optimal to incorporate in versus others?
Well, Delaware is viewed by investors as the preferred state of incorporation because of its long history of corporate law and corporate governance. And so it's a very well-defined law. There are not a lot of issues that have not come up in Delaware, and the majority, I think, of corporations in the United States, certainly the Fortune 500, are incorporated in Delaware. And notwithstanding the desire of some other states to become the preferred location for incorporations, I think that it's probably most beneficial for startup entrepreneurs to think of incorporating or setting up their limited liability company in Delaware and giving it the cachet of having that body of corporate law available. And in addition, having courts that are basically business courts, the Court of Chancery, which is responsible for determining issues related to Delaware corporate law. So it's not as if you're going to a standard court where you may have a judge who's dealing with family law matters one day, commercial litigation the next, and not really an expert in corporate law. So from the investor standpoint, it's probably best to incorporate or set up your LLC in Delaware. And it's not that much more expensive than setting it up in any other state. And I have found, since I get to deal with the authorities in New Jersey, New York, and Delaware is very customer and filer friendly. I mean, you get quick answers by knowledgeable people. I have to say that my experience in New York and New Jersey has not been so promising as it has been with the authorities in the Delaware Secretary of State's office.
Yeah, sounds. Hear that common about business in New York, New Jersey. What are some of the mistakes that a founder makes when either bringing on employees, contractors, or partners into the company?
Well, with respect to vendors, it is incredibly important for any business that creates intellectual property, inventions, trademarks, copyrightable things, documents, brochures, and particularly computer software, which is subject to copyright protection, to have written agreements in place that assign to the company all of the intellectual property rights that the vendor creates. Here's a horror story. You are a startup, you have a little money, you have a friend who volunteers to write some code for your software suite. And he says, no, you don't have to pay me for this. I'll just do it on weekends and at night for you. And then he goes off and does whatever else he's doing. When you get to the due diligence by a potential investor, they'll ask you, well, who has worked on this particular software suite? And you say, well, it was basically me, and my friend Jack. Well, was he an employee? Well, oh no, he just did it as a favor. Well, do you have a written agreement with him? Well, no, it was just sort of informal. That will either end the due diligence and the interest of the investor right there, or they will require that you go and get a written agreement from Jack that says that everything that he did for you belongs to your company, ideally. And if Jack gets a feeling that this is something of great value to you, it may cost you something in terms of your equity or some cash to get him to do that. So tending to that up front is very important, because intellectual property is like lightning in a bottle. And if you don't carefully take the cap off the bottle, the intellectual property can escape, and it's very hard to get it back in the bottle. And the bottle is your company, because an investor wants to know that your company owns all of the intellectual property rights that are necessary to try to make it a success. So having written agreements with vendors and also with employees. The general rule under New Jersey law and the law of most states, as far as I can tell, is that everything the employee creates in terms of intellectual property within the scope of their business belongs to the employer. It is, however, very useful to have a writing that sets that out and helps them understand that, and that they can't be using it on nights and weekends for their own purposes, and it belongs solely to the company. And when they leave the company, they have to turn over all of that material and can't use it anymore. Because if you get a rogue employee who has taken information, some inventions or copyrightable code, and is using that. It's very effective if you have to go to court to prevent that and to stop that, to have a written agreement that you can point to that the person has agreed to. The next problem that I have seen is bringing in a partner, a good friend, you're on great terms, without having some kind of vesting period, so that a person, an employee, a new co-founder who comes in should have a period of time to earn out their equity. If you're in a venture capital deal, the venture capitalists like to see vesting over 4 years with 1 year cliff vesting. That is, you get 25% of your equity if you stay a year. If you leave before the year is up, you get nothing. So you have to stay 1 year to get to 25%. And then in many cases, it vests, the remainder vests monthly, proportionately over the next 36 months. But not having that in place puts you in a position where someone comes in and then leaves shortly after they have started work for the business. And then you go out and do all the work and you create all of the intellectual property and create value in the business. And yet the person who left gets to share in that, even though they had no involvement at all. So it's kind of a feeling of working to earn your equity. And that's where I see mistakes made. And in addition, mistakes with respect to what happens, think through what you want to have happen if a founder or an employee leaves, either without good cause, they just quit and go to work for a competitor. Well, you may want to have the authority to buy back that stock at some nominal price, or if they leave on good terms, you might think about buying it back at some fair value, some asserted value, estimated value, using some independent third party or the general discretion of the board assessing what the stock is worth. But thinking through those things, that's why I think that having a conversation either in an accelerator with experts or with your attorney about what are the things that you should be thinking about is really very helpful to think through. Well, what happens? It's like having a prenup in a marriage. Nobody likes to think that they're going to get divorced, but thinking through things when both parties are harmonious and happy, and very importantly, thinking rationally is very important, because I've seen so many cases where in business relationships, people get so angry that they become irrational and wind up doing things that are actually harming their own self-interest just because they want to spite the other person. And so getting all those things set up front when people are agreeable, even though it may feel a little bit odd, is something that a business attorney can help you do. And it can avoid a lot of pain afterwards.
Yeah. All right, Philip, we're just about out of time. I want to thank you for joining me on an episode of The Agent of Wealth. Before we close, where can listeners go to learn more about your work or get in touch with you directly?
Oh, thank you, Max. We have a extensive website with a lot of free information for innovators. It's at Crowley Law LLC.com. If you'd like to arrange for consultation, you can send us an email at info@CrowleyLawLLC.com. That's CROWLEY LAWLLC. And we too have a podcast that you can tune into where we talk to innovators about their experiences and what they have learned on their pathways to commercialization of products. And so we are very eager to help those who are looking to establish technology-based businesses, and want to wish your listeners, Max, great success in their work to improve our society.
Great. We'll include all that information in the resources section of the show notes. Thanks again, Philip, and thank you to everyone who tuned in today. Don't forget to follow the Agent of Wealth on the platform you listen from and leave us a review of the show. We're currently accepting new clients, and if you'd like to schedule a one-on-one consultation with our advisors, please do so at bautisfinancial.com/call.
Thank you for listening to the Agent of Wealth podcast. Click the subscribe button below to be notified when new episodes become available. The information covered represents the views and opinions of the guests and does not necessarily represent the views or opinions of Bautis Financial. The content has been made available for informational and educational purposes only and is not intended to be a substitute for professional financial planning and investment advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investments and financial planning.